Welcome to the afternoon session of the fourth day. We continue this afternoon with Madam Akila Ramalingam, our lawyer from Chennai. For your information, the morning session that we had with Akila is already on YouTube and has already been circulated to all of you. I want to already announce that as this meeting is going on, you will receive your link from your facilitator for the facilitators review meeting with each one of you separately at 5:30 when this meeting is over. Thank you. Welcome, Akila. Floor is yours.
Thank you very much. So let's continue where we left off. And I hope all of you have had a good rest and feel refreshed and want to continue with studying further laws relating to human rights. Now, what we will do in this session is primarily an enumeration exercise. So we are going to enumerate some of the laws that you will find useful and important in introducing yourselves to human rights laws, as well as pursuing your interest in this area of human rights. There's no need to feel any anxiety that we are going really fast, because you do have dedicated sessions that are coming your way, which will elaborate on almost all of these topics that I have listed out in this presentation. This is, like we already said in the morning, an overview. We won't have much time to delve into the nuances of each law, but to give you a broad strokes understanding of where we stand. So this should start you thinking about the law and critically engaging with the law. So without any further ado, if you can recall, we stopped at looking at laws relating to gender justice, relating to women. Let's move on to the next theme of understanding child rights as human rights. Again, there is going to be a specific session where an expert addresses you on specific issues and sharing their experiences with you. But let's just first get a broad understanding of this area. India is a signatory to the UNCRC, the United Nations Conventions on the Rights of the Child. A lot of the laws that we have in this country are informed by India's international commitment by signing and ratifying the UN Convention. So what we have is, there are several laws relating to child rights, and I have enumerated a few of them in this particular slide. When it comes to child sexual abuse and protection of children from violence, especially sexual violence, the more recent legislation is the POCSO that a lot of you may be familiar with, Protection of Children from Sexual Offences Act, which was enacted in 2012. We'll deal with it in a little bit more detail in a couple of minutes. We also have the Prohibition of Child Marriage Act of 2006. There is the Child and Adolescent Labor Prohibition and Regulation Act, which prohibits and regulates child labor, as the title would suggest. There's the Juvenile Justice Act, which actually embodies a lot of the commitment that India had made at the UN. However, we will see that there are a lot of concerns, especially in its modern version, in the latest enactment. There also is the Right to Education Act, which primarily is enforcing this child right commitment. Okay, so let's first go to POCSO. The POCSO Act was legislated much later. This was not a part of the original laws. This was legislated only in 2012. If you recall, we spoke earlier about how criminal laws had undergone tremendous amounts of reform in the 2010s. And all of this need to be seen in the context of post-Nirbhaya incident, as well as this is the result of a lot of child rights organizations asking and demanding laws that are specific to child sexual abuse. Earlier, we didn't have a dedicated law to this effect. Few provisions of the IPC had to be used, particularly Section 377, which we'll come to in a little while, which spoke about unnatural sex against the order of nature, to criminalize and prosecute instances of child sexual abuse. POCSO came about as a specific uh, legislation to handle issues of child sexual abuse. So what it has, what you see in front of you, are a list of offenses and punishment that POCSO Act speaks of. I'm not going to go into each one of these. We have these slides with a bit more detail than I would be addressing in my address, because we don't have the time, but we want you to have this information. You can use this PPT as a ready reckoner to get this overall picture. So POCSO specifies what amounts to, it defines offenses of sexual assault, of child pornography, sexual harassment, etc. And it specifies these punishments. What POCSO also speaks of, some of the salient features deal with mandatory reporting, in that any person who has knowledge that a child has been subject to sexual abuse will have to report it to the police. And this responsibility primarily falls on, say, the police itself having come to know, on healthcare professionals who may have come to know of such information, where a child is brought to a medical professional, and the medical professional, the doctor, discovers that the child has been subject to sexual abuse. They will have to mandatorily report it. Now, this mandatory reporting has been a double-sided sword, or a double-sided weapon. And there is some evidence to suggest that this in itself has been deterring a lot of reporting of crimes. This is just something that you may keep in mind while looking at uh, child rights in specific in later sessions. But the POCSO is, like I said, a focused law dealing with children who are being subject to sexual abuse. It also has a lot of procedural safeguards, and it has special procedures relating to how do you treat children who are victims, survivors of uh, sexual abuse. How do you handle them as witnesses? How should they be treated? They should not be subject to the same kind of investigation that an adult would, for obvious reasons, that their trauma should not be compounded, that best interest of the child is kept in mind. So there are a lot of child-friendly procedures, and a special court is also constituted in order to deal with these issues in a sensitive manner. Next law that I want to quickly touch upon is the Prohibition of Child Marriage Act. Child marriage, as all of us know, is invalid. Solemnizing such child marriages is considered an offense, a punishable offense. But what you need to keep in mind is that where a child marriage is solemnized, even though it is an offense, it does not mean that the marriage itself is unlawful or that it is void. So while the Prohibition of Child Marriage Act speaks about how do you deal with prosecution, it also deals with restraining child marriage from taking place. So it actually has dedicated personnel appointed under the act who are field workers, who, when they receive information that a child marriage is going to take place imminently, can spring into action and can even restrain that marriage from taking place. And this has been fairly effective, even in parts of Tamil Nadu. But the effect of a child marriage having been successfully completed does not mean that it is in itself invalid. And there are important reasons for this. Remember, we already spoke about how civil laws are separate from criminal laws. So even though the underlying act may be criminal for the person, for the adult who's solemnizing the marriage, it needs to be considered legal, because if there are children who are born out of the marriage, they should be considered legitimate. They should get property rights. The girl who has been married off to an adult, say, would need to get maintenance rights and other property rights. So, in order to safeguard those incidental civil rights, the child marriage itself is not invalid as per law, but solemnizing this is definitely an offense. Uh, the next law that we will quickly look at is the Child Labor Act, Child and Adolescent Labor Prohibition and Regulation Act. Again, the title of this act itself would suggest what it deals with. Child labor is prohibited, adolescent labor is regulated. So, engagement of children under 14 years in all occupations is prohibited. There are some limited exceptions of, say, working in the arts, you have child actors, etc. But generally, engagement of all children under 14 years is prohibited. Engagement of adolescents who are in the age group of 14 to 18 in hazardous occupations is prohibited. And there are specific punishments that are also provided in this Child Labor Act. The next law that I want to spend some time talking about is the Juvenile Justice Act, which has been more recently changed, and we have a newer iteration. The Juvenile Justice Act is one of the more comprehensive laws that deals with two kinds of children. One are children who are in need of care and protection. So those who don't have parents or a family or have been abandoned, children in need of care and protection. And also children in conflict with the law, where a child has committed an offense that is considered a crime and that generally would result in punishment of imprisonment or fine. So where a child commits an offense, they are children in conflict with the law. And the Juvenile Justice Act deals with both these categories of children. India is a signatory to the UNCRC, which I already spoke about, and the definition of child under the UN Convention are persons under 18 years of age. So the legal limit for considering someone a child is 18 years. The earlier Juvenile Justice Act, which was repealed and replaced by this one, spoke of all children under 18 years and treated all of them equally, even those who might have committed very serious offenses would be treated as children, and there is a particular process that follows. They would not be treated as adults for the purposes of investigation, prosecution, and punishment. Whereas the Juvenile Justice Act, which has been more recently enacted, changes this a lot, where heinous offenses, which are basically offenses attracting more than 7 years imprisonment, where they are committed by children, they can be treated as adults and they can be subjected to criminal trial and punishment. So this was enacted after the Nirbhaya incident, where there was a lot of public outcry, a lot of popular demand, in fact, to punish the juvenile, the adolescent involved in the crime as well. There was a lot of outrage that they were not being subjected to trial in the same manner, which is why this Juvenile Justice Act, this particular change was also made. Is this compatible with the UNCRC is a question that a lot of activists are raising. They say that it is in violation of India's commitment at the UNCRC that all children under 18 years of age should not be treated as adults and should not be subjected to an ordinary, an adult-like criminal process. And there are several reasons for this line of argument, which I'm sure you will deal with in later sessions. But please just understand that this is a more recent change in the law, and there is a lot of anxiety amongst activists in light of this change. When it comes to children in need of care and protection, there are child welfare committees and there are district child protection units in place at the district level to deal with children who need care. So, enabling provisions in this include, foster care or adoption that can be done under the aegis under this umbrella legislation. So the Juvenile Justice Act also specifies a number of offenses of where children are mistreated. So employing children for begging, etc., engaging them in bonded labor, selling them, so trafficking in children, all of these are specific offenses under the Juvenile Justice Act as well. Please do remember that in addition to this, general provisions of the Indian Penal Code or any other specific legislation will also apply together. So it is not the case that you need to choose one offense, either you need to choose between laws. They will work together. So that is how children who need care and protection and children who may be in conflict with the law are treated as of now. I also want to quickly talk about the right to education. Again, you have a session dealing with this as well, I understand. Article 21A of the Constitution, which is a fundamental right. This was introduced in 2002, by the way, speaks of free and compulsory education of all children in the age group of 6 to 14 years of age. Article 45, which is the directive principles of state policy. Please try to recollect our fairly detailed discussion about the difference between fundamental rights and directive principles of state policy that we had in the morning. Fundamental rights are immediately enforceable, judicial or justiciable. Directive principles of state policy are conceived as welfare goals of the state. Article 45 speaks about the endeavor to provide early childhood care and education up to 6 years. So what the right to education as fundamental right is a specific age group of 6 to 14 years. Pursuant to this constitutional amendment, the Right to Education Act of 2009 was enacted. And the Right to Education Act provides for free and compulsory elementary education up to class 8. And it introduces this idea of neighborhood schools. So the idea is that all children should be able to access schools that are in the vicinity of their residence, a neighborhood school up to class 8. And the way in which the government wants to implement this goal is that in addition to government schools, private schools also would have to take on children from marginalized, backward backgrounds, and they should take 25% of their intake should be children from varied backgrounds. And the way in which the act is implemented is that fee of these children from disadvantaged backgrounds would be reimbursed by the state. There was a lot of challenges raised to this, constitutional challenges raised to this act by private schools. As we know, private education in this country is a serious lobby, is a serious force to be reckoned with, and private institutions challenged this. This act was upheld. There are several critiques of the RTE Act. One is about its implementation. There are several discontents about its implementation. One of the critique of the law itself is that it is under-inclusive, meaning it leaves out children belonging to age 0 to 6. Early childhood care and education is as important to the development of children. Also, it leaves out the age group of 14 to 18 of high school going children. So it only tries to cover a very specific subset, and that it is under-inclusive in both of these categories. There are other fundamental critiques of RTE as well as to how, and there is evidence to suggest that because of the implementation of RTE Act, government schools are not receiving sufficient priority. Instead, there is some kind of endorsement of private school education itself, and that it may be better instead to just invest in public free education. Again, these are issues for you to think about. This is the present architecture of the Right to Education Act. um, Let me quickly also talk about LGBTIQ, sexual minorities, rights of sexual minorities, and then we will take a break for question and answers. Now, when it comes to rights of sexual minorities, this again is an area where human rights activists and LGBT groups, communities have been extremely passionate and been engaging with the law for several years and have received some amount of victory through their persistent efforts, through their grassroots mobilization, through approaching courts, through, by accessing media in interesting ways. So I think it would be an interesting case study to look at how to do activism. And when it comes to rights of sexual minorities, I need to start with a small story of Section 377 of the IPC. Now, Section 377 of the IPC was a colonial piece of legislation which criminalized unnatural sex against the order of nature. So, what this meant was even consensual sexual activity between people of the same sex was considered criminal. So this is where there is no victim, in that the act was solely consensual. Both parties wanted a particular kind of sexual interaction. However, the law, for different reasons of morality, public morality, and I have to put that in quotes, criminalized this. Now, this was a colonial piece of legislation which stayed in the statute books, uh, and it was challenged by NAS Foundation, which is uh, an NGO that works very actively on LGBT rights, and the Delhi High Court in 2009. So, if you remember, IPC was enacted in 1860. So, we've had so many years, more than 100 years of having this on the statute books. The Delhi High Court struck it down in a wonderful judgment, where they said that consensual activity of adults cannot be, is again, a part of people's fundamental rights. The state cannot intrude into these personal choices regarding their private life, regarding their sexuality, and therefore read down Section 377 and said that, well, any other kind of so where it came to non-consensual sexual relations, 377 still could still be used, but for consensual sex, 377 cannot be used. Now, the one of the more convincing arguments that the state had put forth in this case is that Section 377 is needed because that was the only provision which the state was using to prosecute cases of child sexual abuse. So they, remember I told you POCSO is more recent, was enacted only in 2012. This is much earlier. Around then, Section 377 was the only provision that could be used, especially to prosecute instances where male children, boys, were being subject to sexual abuse. So the court took this into account. It didn't fully strike down Section 377, but it read it down to mean that you can't have adults being prosecuted, adults who are sexual minorities, who are consensually engaging in unnatural sex, quote unquote, same-sex relations. So this was in 2009. This was later reversed by the Supreme Court in this judgment called Suresh Kumar Kaushal versus NAS Foundation, where the court basically said this is an issue concerning a minuscule minority. And therefore, if you are to read down Section 377, it is something that has to be done by the parliament and not by the court. So basically passed the buck on. It didn't say that whether you should have this law or not. It basically said this belongs to the domain of the parliament. It cannot be decided by the courts, and essentially revived Section 377. This went on further appeal. It's called a curative petition, where because it was such an outrageously wrong judgment, the Supreme Court itself took up this case again. And in this judgment called Navtej Singh Johar, the Supreme Court read down Section 377 again and restored the reasoning of NAS Foundation of the Delhi High Court. This was interesting because Navtej Singh Johar, one of the interesting strategies that was employed in this litigation was that people from LGBT communities themselves came forward as petitioners. Because in the 2013 litigation, one of the questions that was raised by the court was, who are people who are LGBT? Have you seen them? Have they come before this court? So there was a lot of ignorance on the part of the court in understanding issues relating to LGBT community. So the strategy in this litigation itself was changed a little bit. The petitioners in this case were very successful, socially active, preeminent persons belonging to the LGBT community itself. And perhaps part of the reason why this litigation was successful, one of the many reasons, yes. Another important case is the NALSA judgment, National Legal Services Authority versus Union of India, which upheld rights of transgenders. And in this particular case, the Supreme Court held that transgenders are a third gender, and also very importantly said that there should be self-identification of gender. So it is not somebody else certifying another person to be male, female, or third gender, that we have a right to self-identify our gender, and therefore that sex reassignment procedures are not mandatory. Now, this is extremely important in the LGBT, especially trans community, where we know that for a variety of reasons, mainly monetary reasons or for other reasons, you may not have sex reassignment procedures. You cannot be forced to undergo sex reassignment procedure in order to change your gender identity. This was the NALSA judgment. Now we more recently have the Transgender Persons Act, which was passed in 2019, which goes back on the interpretation and a lot of the progress that was made by the Supreme Court in the NALSA case. What the Transgender Persons Act does is moves away from this idea of self-identification and instead requires you to have legal recognition as a trans person. So there is a two-step process here. One is, if I want to change my identity as a transgender person, then I'll have to apply to the district magistrate. And this is based on self-declaration. But if I want to change my gender in my identity documents, this will be done only on the basis of surgical records. So sex reassignment surgery becomes a precondition for changing of gender. This goes against what the Supreme Court itself had elaborated as an important fundamental right. So there is a challenge that has been made to this act, and it is pending before the Supreme Court right now. So let me stop here for questions.
Thank you, Akila. Can I ask you a few selected questions?
Sure.
Okay. There are 5 more or less around each other. Whether female genital mutilation is treated as sexual offense under POSCO. Second question is, if the child goes to work in a tea stall or for domestic work, who's under 14, goes for this work after school, does it come under child labor?
Under 14 years.
Under 14.
Okay.
Under 14 years.
Okay.
Are there any specific rights for infants?
Mm-hmm.
This is one specific question.
Okay.
If you can define what is sexual minority, or is there any set definitions?
Mm-hmm.
What are general parameters to treat a juvenile as adult?
Mm-hmm.
And a question just came as I was reading, whether transgenders are allowed to marry, legally marry.
Mm-mm-mm.
Yeah. That's all.
Okay. Okay. Thank you for those really interesting questions. Some of them I'm sure will keep me up tonight when I will keep thinking about are my answers correct or not. But thank you for those really provocative questions. First question about is female genital mutilation a sexual offense under POCSO? That is going to be really interesting. It definitely will be assault. Is it a sexual offense? It could be argued that it is, because in POCSO you don't need an intent to um, commit sexual abuse, because we know that a lot of FGM is also carried out by the family for various cultural reasons, etc. So can we consider this a sexual offense under POCSO? Perhaps. I have not come across decisions to this effect. Someone can correct me if I'm wrong, but it definitely will come under assault laws, several general laws, as well as being violative. But I will want to read POCSO again but I think it could come under sexual offense, even though there may be no intent to sexually abuse. That's my answer for now, but let me keep thinking about it. The second question was, say a child under 14 years of age works at a tea stall after school. Is that child labor? And the answer is yes, it is child labor. Please go through the slide that we had already referred to earlier. Rights of infants, that again is a really, really interesting question, because when it comes to rights of children, of infants, it's almost always couched as rights of parents over those infants. But this is really interesting because the general principle behind child rights law itself is best interests and welfare of the child. So this is applicable from age 0 to 18. So do infants have rights? Absolutely yes. Usually it is understood as having access to parents and having access to their birth family. But under many circumstances, if they are facing some kind of abuse, etc., then the state comes in. And remember, we spoke about the Juvenile Justice Act, which has a specific category called children in need of care and protection. So those are examples of, rights of infants being implemented by the law. So yes, infants do have rights. It can be exercised via the parents. It can be exercised by other people speaking for the child, exercised by the state itself. And often, who resolves these rights? Where there is a conflict, you'll have to go to court, where the court can then assign a different guardian, can then decide on the upbringing of the child. Um, how do we define sexual minorities? There is no legal definition. Sexuality is on a spectrum, and we now understand that gender is not a binary, sexual orientation is not a binary, it works on a spectrum. Therefore, sexual minorities are those who don't fall under the dominant identities that are socially prescribed and endorsed. So I would say those who don't identify themselves as heterosexual, those who don't identify in terms of, again, this could also include your gender identity itself. those who don't identify with with the gender that was assigned to them at birth are sexual minorities. So this terminology again has been undergoing a lot of change, given a lot of activism and a lot of awareness around these issues. So you have LGBTQIA plus, and that is how a lot of alliances now identify themselves. So it could be various others. So it's a spectrum. I would say sexual minorities are those who are not necessarily straight, who don't identify as straight, who don't identify with the gender that they are born with. What parameters are there to treat a juvenile as an adult for criminal proceedings? Those who have committed heinous offenses, which means serious offenses carrying punishment of more than 7 years. There would be a hearing which is conducted by the Juvenile Justice Board, where they will take a call on whether or not this child should be treated as an adult for the purposes of the law. And they will look into, what was the kind of offense that was perpetrated, what was the intent of this juvenile, and is it fair for this juvenile to be treated as an adult, basically. Can trans persons marry? Yes, they can marry, but now it is going to be a little, and this will depend on the gender that is there in their identity documents. So, like I said, with the Transgender Persons Act, changing your gender is not easy. You can't self-identify. You have to have sexual reassignment, sort of surgical procedures that happen. And you can marry only a person of the opposite sex, depending on their gender in their identity documents. So those are my answers.
Yes, we can continue. We can continue now.
Okay.
Yeah. Any more clarifications or doubts with regard to children? Other themes we'll be taking up in thematic, which are to follow your session. Yeah.
Yeah. Okay. So in this section, we'll be talking about persons with disabilities, Dalit rights, and tribal rights. And I'm going to try to go a little bit faster so that we'll have a lot of time for Q&A, and later maybe even think a little more critically about these laws. Now, person with disabilities, we have the PWD Act, Persons with Disabilities Act of 2016. And this was a law that was specifically enacted to give effect to the United Nations Conventions on Disability Rights. What this law does is that it lists a number of disabilities, 21 disabilities actually, and specifies certain rights and certain promises regarding their treatment. So this act actually increased the number of these categories from I think 7 to 21, but more disabilities can be notified by the government, which is basically a policy decision that has to be taken by the government. So from blindness to low vision, leprosy cured patients, hearing impairment, locomotor disability, dwarfism, intellectual disability, mental illness, autism disorder, cerebral palsy, muscular dystrophy, etc. So I am not going to read out all of these, but the PW Act specifies these lists of disabilities and provides for certain protections. Now, what are the protection? It mainly says that the appropriate government, so it could be the state government, it could be the central government, it could be local government, whichever, shall ensure that persons with disabilities enjoy a right to life, equality, life with dignity, and respect for their own integrity. But others, which means that there has to be non-discrimination, that there will have to be accommodation of particular disabilities in order to ensure their participation in personal life, in work life, in public life, right? So very simply put, this means anything from public buildings need to be wheelchair friendly. Anything from you need to put in place infrastructure, that makes it easy for persons with, say, hearing impairment or vision impairment to access important public infrastructure, right? So it means all of the above. These are promises that are made here. I'm sure in later sessions, you will understand how it has been implemented. But what this says is there should be no discrimination on the basis of disability. So a person cannot be excluded from education, from access to access to employment, to any other access, even to, say, a restaurant or other places like that, on the basis, for the reason that they have a specific disability. So in light of having affirmative action to better the conditions of persons with disabilities, there is some amount of reservation in educational institutions as well as jobs in government establishment that is specified in the Act. Now, another legislation, remember the PWD Act itself spoke about mental illness, but when it comes to persons with uh, disability, or psychosocial disability is one of the terminology that is preferred in this particular case, where you have persons with mental illness issues with psychosocial disabilities. There's another legislation called the Mental Health Care Act of 2017, which would deal with access to medical health care, which deals with how to ensure that rights of those with mental impairment, with mental health issues, are protected. So this Mental Health Care Act, so just to give you a quick background, say a person has a serious mental illness issue. The traditional way of dealing with this is that they are pretty much robbed of their personhood. They are not considered as persons who can hold property, who can, say, get married, who can enter into contracts, right? Traditionally, laws would just deal with these people as lunatics or consider them insane, right? Again, we need to understand that mental illness also is a spectrum, right? And a person with a specific kind of mental disability or mental health issue does not mean that they are incapable of making their own decisions. They are incapable of leading fairly normal lives and having particular rights. So the Mental Health Care Act is not a perfect legislation, but it is one step forward in that it recognizes some amount of agency. Earlier, where a person is alleged to be mentally ill, a guardian will be appointed for them, and it's the guardian who would take all decisions relating to their personal life, relating to their healthcare, relating to any property they may come to own, relating to everything else. But the Mental Health Care Act takes one step forward in that there should be consultation and there is some right to community living, etc. The Mental Health Care Act also decriminalizes the attempt to suicide in a slightly controversial way. There always was some amount of debate amongst civil rights activists as to whether or not the attempt to suicide should be criminal or not. The legislation decriminalizes the attempt to suicide in a way by which it says, persons who have mental health issues, if a person attempts to commit suicide, they will not be prosecuted, but there will be an assumption that they have medical health issues, and therefore there will be, the treatment and rehabilitation measures there. This does go against the right to autonomy, but again, I just wanted to flag that issue, because when the Mental Health Care Act of 2017 was passed, you had this provision that does not necessarily fit in within the scheme of this act, but was, and therefore was controversial. But I just thought I'll flag this for you to read up for yourselves. The Mental Health Care Act, like I said, deals with ethics of medical care. So there should be confidentiality that is maintained, that you can't have cruel, inhuman treatments. And this again is informed by our particular reality, background, where people in mental asylum have been subject to extreme torture. They are not treated with dignity. So these rights regarding their own healthcare and their own decisions, again, are built into this act. I Let me quickly move on as well to issues relating to Dalit rights and tribal rights. There are two main legislations when it comes to Dalit rights. One is the Protection of Civil Rights Act of 1955, and the preamble has been excerpted for your perusal, to prescribe punishment for the preaching and practice of untouchability, for the enforcement of any disability arising therefrom, and matters connected therewith. Remember, Article 17 of the Constitution is a prohibition of the practice of untouchability, and therefrom sort of comes the Protection of Civil Rights Act. Protection of Civil Rights Act has these offenses. You will see that the punishment is somewhat minimal. So enforcing religious disabilities, enforcing social disabilities, where you bar a person from entering a place of worship and thereby, perpetuating untouchability by barring persons access to public places, etc., by boycotting them from accessing such public infrastructure, refusing to sell goods to people, violation of Article 17, compelling any person to do scavenging or sweeping and such degrading treatment, etc., are punishable offenses under the Protection of Civil Rights Act. Now, this Protection of Civil Rights Act was considered insufficient, and thereafter the SC/ST Atrocities Act was enacted in 1989, and the preamble speaks of the objects of the legislation to prevent the commission of offenses of atrocities against members of scheduled castes and tribes, to provide for special courts, and also relief and rehabilitation of victims. So the SC/ST Act builds on the PCR, Protection of Civil Rights Act, specifies further offenses, atrocities, specifies the kind of criminal process, which is a slightly modified version of your regular process itself, and also constitutes special courts to deal with these offenses. So I have listed out all of the offenses which you can review at your leisure. But just remember that this is going to be an unusually long and detailed provision, offenses under what are considered atrocities. And all of these are informed from societal practices. There are many, many ways in which we know this, being a part of this society, many ways in which the caste system is perpetuated, caste superiority is sought to be achieved, and inferiority is sought to be perpetuated. And the SC/ST Act tries to list out as comprehensively as possible modes in which this kind of caste-based atrocity is carried out. So if you see, these offenses on this slide carry with them punishment of 6 months to 5 years, which is putting any inedible or obnoxious substance into the mouth of an SC/ST person, dumping excreta, etc., at premises occupied by an SC/ST person, dumping these substances in the neighborhood of an SC/ST person with intent to cause injury or insult, garlanding SC/ST persons with footwear, or parading them naked or semi-naked, forcibly committing any act which is derogatory to human dignity, wrongfully occupying their land, wrongfully dispossessing their land. So again, all of these have been ways in which atrocities have been carried out, and the act lists them almost comprehensively and makes them an offense, right? Uh, so it also speaks of what is economic and social boycott. Remember, the Protection of Civil Rights Act also had similar provisions. You cannot, all of this is to counter the societal reality of untouchability in its myriad forms, right? And again, there are other offenses as well, which we have listed. Now, one of the important features is that the SC/ST Act is applicable where a person who does not belong to the SC/ST community commits such an offense on a person who is an SC/ST who belongs to this community. So, where both the perpetrator and the victim belong to the SC/ST community, this legislation does not apply. Okay. Uh, and there are pros and cons to this interpretation, to this uh, this this designing of the law, because we know that even within Dalits there still is a caste hierarchy. Even within the SC/ST, SC/ST are again umbrella terms that we use for convenience, right, to have a convenient legal category. But even within this there are hierarchies. So how do we understand this does become a little tricky, but this is how the law is for now. um, I also want to quickly touch on tribal rights. The SC/ST Act, etc., that we spoke of earlier will also apply to persons who are tribals. In addition, there are specific challenges facing tribal communities. Again, you have a dedicated session. I don't want to impinge too much on those, but I want to just uh, point out certain laws that exist for you to ruminate about and come back to in your future session. The Constitution provides for specific scheduled areas, and it provides for self-governance and slightly differing legal regimes relating to those scheduled areas. The Panchayat Extension to Scheduled Areas Act, the PESA Act of 1996, basically allows for self-governance through Gram Sabhas and Panchayat. This does not mean that state laws are not applicable or central laws are not applicable. There is some amount of devolution of power because of their individualistic, their different orientation to community and law, in order to recognize their specific cultural rights. Another important law relating to tribal rights is the Forest Rights Act, which is the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forests Act of 2006. Uh, this is an important piece of legislation because one of the main issues that Adivasis tribals have been fighting over is their access to forest and access to property rights. So during the colonial period, a lot of the tribals' customary rights to their property was stripped uh, by various colonial laws and policies. And these laws essentially made tribals who had been using forests and community resources for centuries, it saw them as encroachers of forest land. And in order to give back some amount of property rights and usage rights, and to recognize their use of community properties, the Forest Rights Act was enacted. And the Forest Right Act speaks of some kind of process by which people's rights can be evaluated and access can be granted. This again has been quite controversial, even especially recently, where there was a judgment of the Supreme Court that upheld eviction of over 1.2 million people, considering them as trespassers and encroachers. But that has been stayed by the Supreme Court and hopefully will be seen again, would be reviewed again. But these are some of the issues that concern tribal rights. So let me stop now for questions. And then in the next session, we'll move on to labor law and environmental rights.
Yes. So just a few questions here.
Yeah.
I'm just selecting one for each topic so that we have more time.
Sure.
Okay. So one question was with regard to disability. Are schools, public institutions, or for example, hotels, restaurants, etc., has a duty to arrange for the basic need for accessing these institutions? Second question is, does mental health care talks about employment of people with mental illness? And a question just came with regard to the SC/ST Act. Does the SC/ST Act talk about denotified tribes?
Okay. Anything else?
That's the three.
Okay. So the Disabilities Act does require schools and public places to ensure accessibility. It does do that. The second question was about the Mental Health Care Act and whether or not it speaks about employment opportunities, etc. No, it doesn't. But the Persons with Disabilities Act does, not the Mental Health Care Act itself. So if you recall, the Persons with Disability Act specifies 21 categories, and one of them includes mental illness. So unless there is a reason why a person with a specific kind of mental disability cannot perform a particular job, unless there is a direct correlation, you can't discriminate and you cannot deprive them of such an opportunity. So the Mental Health Care Act itself does not provide for that, but the Persons with Disability Act may be of limited service. Does the SC/ST Act also speak of denotified tribes? Yes, it is common to, so if a person belongs to a scheduled caste or scheduled tribe, this could be a denotified tribe or any other, then the SC/ST Atrocities Act is still applicable. So that is my short answer. Can we move on to the next section?
Yes, we can.
Okay. All right. So I want to keep this going crisp so that we will have some more time to discuss general questions. I want to talk of two different themes in this last session very quickly: labor laws and environmental laws. Again, these always were some of the more important rights, but especially in today's day and age, we see this confronting us in the news, confronting us in our everyday realities, where we are confronted with extremely disturbing images, facts about how migrant labor is treated, about how the poor are left with very little recourse today. So some of the labor laws that exist. Now, the background to these labor laws we already saw in the morning session comes from Directive Principles of State Policy, which sets out welfare goals of the government, that India is supposed to be somewhat socialist and there should be a right to livelihood of all people, right? And this has been interpreted to be a part of fundamental rights. This is an important human right which is guaranteed to each person. Now, it is in this background that we need to look at all labor laws. Directive principles in great detail speaks about the need to protect various aspects of labor rights, from occupational health and safety to levels of nutrition of people, right? All of these are directly mentioned in the directive principles of state policy itself. And what we have in India uh, are various laws. There are more than 40 laws that deal with labor rights. These are somewhat fractured. Most of them apply only to the formal sector, which in itself should give you an idea as to how many people are covered by these laws. It still is a lot of people by absolute numbers. Please don't get me wrong. But we need to remember that a lot of the labor force also works outside of the formal sector and may not be direct beneficiaries of the existing labor laws. Also, bear in mind that the present government is in the process of quote unquote reforming labor laws. They are trying to come up with comprehensive labor codes, which in and of itself may not be a bad idea, because laws which are disparate, which is actually fairly difficult to track and keep note of for even us lawyers. But there is very little deliberation that is happening on the contents of this revision itself. And we also now know that in the guise of reforming labor laws, they are actually being scrapped, that too by ordinances, which are executive measures, which are not even legislative measures. So we are in the precipice of chaos and disaster, pretty much. Sorry to be alarmist, but we need to take this urgently, read about this a little bit more, and start thinking about how to engage with them in our own personal capacities. So some of the main labor laws I will list down below. I have listed in the slides that are forthcoming. The Industrial Disputes Act 1947 is a lengthy and therefore probably the first legislation that we should talk about. It is an extremely lengthy law. It provides for dispute resolution mechanism of the formal sector, which employs workmen. So it is how you resolve industrial dispute, where a worker has a problem, has a dispute with the management. The ways in which you resolve these industrial disputes is specified in the Industrial Disputes Act. So this is specifically applicable for workmen who are, who draw less than 10,000 rupees a month, etc. This allows for collective bargaining, and this also is the law which protects against a lot of laying off or lockout and strikes, etc. So industrial disputes are dealt with using the Industrial Disputes Act. When it comes to health and occupational safety, you have the Factories Act of 1948, a very important legislation that specifies important welfare measures relating to how many hours of the week that a person can be forced to work. How do you assign holidays? How do you compute overtime payment, rest and interval? Also other aspects of workplace health, that you should have washrooms, that you should have lighting, that you should have ventilation, that you should have first aid, etc. Now this again is a very detailed legislation in order to make sure that you don't have highly exploitative conditions at the workplace. And it also speaks about needing to have creches, etc. Now, this act again is being revised, and there is a code on occupational safety, health, and working conditions that has been introduced and is awaiting assent by the Parliament. This is also one of the key legislations that is sought to be scrapped by a lot of states. And the effect, I think, would be quite disastrous, because this speaks of number of hours that a person can work, the number of breaks that you need to provide in order to ensure that people are workers' health is not compromised for the sake of quote unquote efficiency or output. Uh, it provides for washrooms and other important protections or measures, right? So there are several other legislations as well. I have just accepted a few. We have the Trade Union Act of 1926, which specifies how trade unions can be registered. Now, you can also have unregistered trade unions. There is no bar on that. But where a registered trade union engages in collective bargaining, there are some amount of protections against, retributive action that is taken against trade unionists. Now, let me end on labor laws by just highlighting some aspects of the Interstate Migrant Workmen Act. As we know, this is one of the burning issues of today in light of the pandemic and the lockdown, where there are alarming number of migrant workers who are stranded in several states, who have no way of going back to their hometowns, and they are not allowed to leave for the main reason that particular states, the host states, don't want migrant labor in order to carry on their economic activity. So this again amounts to forced labor. If you recall, there is a specific provision in the Constitution, Article 23 of the Constitution, which speaks about right against exploitation. You cannot have forced labor. And I think it's quite arguable that where you are forcing a person to engage in economic activity, not allowing them to move away to go home, also amounts to a constitutional fundamental right violation. But the Interstate Migrant Workmen Act, if you see, is a fairly technocratic legislation. It provides for registration and licensing of uh, migrant workers. So what this act does is that where contractors recruit migrant workers from different states, they need to be licensed. Without being licensed, a person cannot act as a recruiter who hires migrant workers. And also, once a person comes to the host state, there should be mandatory registration of establishments employing interstate migrant workmen. And these are, of course, applicable only where you engage more than 5 interstate migrants. So, where there are small enterprises or households that employ 1 or 2 or 3 uh, migrant workers, there is no need to either have license or registration of this. But the important safeguard that this act tries to provide is that it tries to maintain a list of interstate migrant workers. It also provides for non-discrimination, that migrant workers should not be paid a lower wage than a local workman who is engaged in comparable similar activity. Also, the contractor is made liable to pay wages, because there may be a situation where the primary employer does not pay, in which case the contractor is made liable to pay. So this is a technocratic sort of licensing and registration mechanism. But what we have seen in these past months is the abysmal failure of implementation of this law. None of the states were enforcing this law properly. If they had, we at least would have had some amount of information about how many people are stranded, and have some basis to act. As such, this was not a priority for the government for a long time, but the fact that this act was completely neglected and there was complete non-implementation of this act, I think has compounded this difficulty. The Interstate Migrant Workmen Act only speaks of this. Now, I want to quickly talk about environmental rights for like 5 to 10 minutes and then open up for questions. This is a bit of a jump, I know, but please do bear with me. All of these, I think we can understand as, socio economic, socio-cultural rights, and also third generation rights of sustainability, etc. Now, environmental rights and principles relating to environmental rights in India have developed largely due to judicial innovation and public interest litigation. Article 21, which we already saw in the morning, which only speaks about the right to life and personal liberty of persons, has been read to mean that there is a right to life with dignity and with everything that it implies. And this has been read to further mean the right to clean air or drinking water, right to unpolluted air. It has been read to include the principle of sustainable development, of polluter pays, public trust doctrine. These are just some of the principles that I have accepted, which I think are really important for us in understanding environmental rights. I'll just spend a couple of minutes over these principles. And these are all a part of Article 21, which are fundamental rights. Yes, which means these cannot be scrapped at all. We cannot move away from these principles. What is sustainable development? In the inaugural session, Justice Anand Venkatesh also spoke about the right to development. And yes, there is a right to development that all of us do have. But how do we understand right to development? There is a need to adhere to the principles of sustainable development. And the meaning of sustainable development, the meaning is easy, but its enforcement and its actualization is not. It means meeting the needs of the present generation without compromising on the ability of future generations to meet their needs. So we need to ensure that the way in which we exploit natural resources, particularly, is not one that we do with a short-term sort of goal of maximizing output and maximizing economic activity today, but make sure that we leave enough for our future generations. So we cannot exploit and abuse natural resources, even though we have the right to use natural resources. We cannot do it in a way that completely depletes it for future generations. So that is sustainable development. So I'll just give you a quick example. Say we are talking about mining, right? And this is actually a true story. I visited a particular mine where coal mine, and the engineer there was talking to us about sustainability and said, there's no need to worry about this at all. We have enough coal here to last another 100 years. So they were only thinking about future being 100 years, right? You could exhaust that coal reserve in 100 years. Is that sustainable development? So exploiting natural resources without concerning ourselves with how future generations will be able to meet their needs is unsustainable. And this is a part of Article 21. Polluter-based principle, meaning a person who has caused damage, has caused the pollution, will have to pay for the cleanup, right? So this could be the recent the recent gas leak that we saw. Several of these industrial accidents or any other kind of accident that leads to damage either to personal life property or to the general environment, the compensation and the damage will have to be borne by the person who had polluted and had caused this incident, right? So think of the oleum gas leak case, think of the more recent Visakhapatnam tragedy that we are still dealing with. Polluter-based principle is an important part of Article 21. Another important principle that flows from Article 21 is the public trust doctrine. This has been really important in understanding how to divert common resources or how not to divert common resources. And the public trust doctrine says that common natural resources whether it is water, whether it is forest, whether it is sand, mining, etc. These common natural resources are held by the government in trust for the people, for the benefit of the people. So even though technically all rights relating to common resources such as, sand or water, etc., may ultimately vest with the state, because none of this is individual property. Doesn't mean that the state can do anything it wants to exploit it. It cannot be converted for private use. The government is a trustee, and it holds public property in trust for the benefit of the people. So any action that is taken in exploiting these common natural resources should be done in a way that will benefit the people as a whole, and it cannot be converted for personal use of particular industries or particular persons. So this public trust doctrine was instrumental in several cases. Some cases that all of us may be familiar with is the Plachimada case, where Coca-Cola was stopped from exploiting underground water, important pure drinking water. Another example are, sand mining case in Tamil Nadu, where there has been restrictions on exploiting these resources by private parties for private gains. These are environmental principles and rights that inform the whole of environmental law. When we think about the legislations concerning environmental law itself, again, a lot of them are quite technocratic. There are a plethora of legislations, such as the Environmental Protection Act of 1986, which is some kind of an umbrella legislation. This was enacted after the Stockholm Conference, when it was found that earlier we had the Air Act of 1981, the Water Act of 1974, which created pollution control boards. These were considered insufficient, and in order to implement and give effect to the Stockholm Principles, the Environmental Protection Act was enacted. And a lot of the environmental law and regulations are basically regulations that emanate out of the Environmental Protection Act. So there are several legislations which will periodically speak of, pollution levels, the kind of approvals or the kind of assessment that needs to be done before you can undertake particular construction activity or undertake a particular project. So all of these details are mentioned in these laws, and also in several notifications and circulars that flow from these laws. But in my mind, what is important is to understand the rights that are contained in these laws. And these rights were what we spoke of earlier, which emanate from Article 21 and are most definitely part of fundamental rights. So let me end here. Thank you very much for listening to me patiently, I hope. And can I invite some questions, please?
Thank you so much, Akila. Just very few questions. We don't have much time.
Yeah.
Very specifically, are agriculture workers also covered under labor laws? So this is one question. The second question is with regard to, are there any exemptions with regard to labor laws, like with regard to specific situations like SEZs? And the last, do labor laws provide for social securities?
Right.
That's all.
Okay. Again, really interesting questions. Thank you for those who've raised these questions. Even though I don't have the benefit of seeing you or interacting directly with you, thank you for these questions. And my quick answers to some of these questions. Are agricultural workers covered by labor laws? No, not in the present form. But again, there is a caveat here. See, like I told you, the laws are being revised right now, and there is a code on wages that has been passed, which specifies minimum wages, even though there's a lot of confusion about what the wages are right now. The center is supposed to specify a floor wage, and then states are supposed to specify minimum wages that are above that. And this code on wages speaks of employment of all categories, whether it's in the formal or the informal sector. So technically they would be covered by some, right, in terms of the code on wages. Interestingly, something like the Sexual Harassment at Workplace Act can also apply to agricultural workers. Now, the big difficulty is going to be implementation of these laws. There is very little awareness on rights of persons working in the informal sector or outside of, say, a factory setting, really. So the problem in implementation of these laws is tremendous, but let's look at them as challenges and try to overcome them anyway. So yeah, there will be some laws that are applicable. Obviously, something like the Factories Act may not be applicable, but there will be some basic social security features that are available. Second question was about our SEZs exempt from labor laws. Yes, there is some amount of exemption that is provided to SEZ. And this is a disturbing trend that we are now seeing, being taken to its logical conclusion, right? Where for reasons of apparently economic revival, we are told that we need to give up labor laws and, very hard won rights under these labor legislations. So yes, there are these exceptions, and it is a very disturbing trend indeed. Okay, the next question was about social security, and Matthew, can you just repeat that, please?
Yeah, do labor laws provide for social securities?
Okay. Yes, labor laws do provide for social security. Like I told you, the minimum wages, the code on wages is one such. There are EPF and Gratuity Act and several other legislations that provide for some amount of, or ESIC, so the Employment Provident Fund. There is the Gratuity Act. There is Payment of Bonus Act. There is the Employment State Insurance Corporation. These are just legislations that I can think of from the top of my head. There are all of these social security laws. Like I mentioned earlier, these are applicable mainly to the formal sector. Very little of this is applicable to the informal sector. Yeah, that's my answer, Matthew.
Thank you, Akila. Thank you so much for covering a broad range. So I leave it to Henry now. Henry, you can take it from here and conclude.
Akila, thank you very much. And I'm sure the participants join me in thanking you. You concentrated on something which was very, very difficult, trying to look at all the laws relating to all the subjects that were listed. I want people to understand that Akila indicated the source of these laws and the foundations and principles of some of the laws. She concentrated on that. It would be nice if you could go back and listen to the YouTube again, listen to her on the YouTube again, and then that process would easily get internalized. Now, I'm sure you have many questions. In order to ensure that we have a sufficient number of questions in advance, I am proposing the following. All of you have your course curriculum details in your hand. Just note the following slight changes. On the 15th, we will not be having the proposed session in the afternoon, U4, L4. Instead, it will be on the right to food. on the right to food. And we will be having Kavita Srivastava from Jaipur in Rajasthan to handle the session. The best on right to food in the country, to my knowledge. That is change number 1. The next change will be the following day. Professor Nandini Sundar has expressed her inability because her father has been rushed to hospital and she has to attend to him. And she is actually attending to him in hospital. She thought it would be very embarrassing to speak from hospital. We are finding a replacement. It is only a replacement. On the 19th, you have definitely a change. On the 19th, you will be having in the afternoon, instead of right to food, hear me carefully, the title is Right to Love. I hope all of you got the topic. It is not right to food there because right to food has already come tomorrow. On 19th afternoon at 4 o'clock, the title is Right to Love, to be handled by Advocate Arvind Narayanan from Bangalore, which will be on the right of sexual minorities. The topic has to change, Right to Love. I hope all the professors have corrected it properly. The correction is particularly for professors, Right to Love. My goodness, imagine them teaching Right to Love in their value education class or their human rights class. So these are, and then of course on the 19th afternoon, housing rights will be handled as scheduled by Madam Shivani, the Executive Director of the Housing and Land Rights Network in New Delhi. Now, why I mentioned all this is for the following. Akila has created a lot of taste on women's rights, child rights, Dalit rights, tribal rights, denotified tribes, persons with disabilities, sexual minorities, policing. Of course, she has done on policing. Therefore, you are free to send questions in advance. You are free to send questions in advance on these topics, provided you put your registration, the topic as per your schedule. In your course curriculum, we have got the topic and the speaker to whom it is addressed. The speaker is written there. The change the speakers I have given. If you go wrong on 1 or 2 speakers, doesn't matter. So that Matthew and our team would be able to address, Rajavel would be able to address these questions to the speakers even before they come. So they know exactly what all you are thinking and they will try to incorporate that in their presentations if possible. I hope you will be able to do that. This is to cater to your tastes in advance. This is the advanced menu. This is the advanced menu. So that Peggy or whoever is the menu deliverer would be able to bring it properly to you when they present. That's it for the moment. People are very, very unhappy with me because I have not given them an activity today. And because I have not given them an activity today, I'm giving you a taste of an activity today. Please go to the website of the National Law University, Delhi. I see a smile on Akila's face. And the smile is because she taught there.
Yes.
And go and look at Project 39A. This is a project of the National Law University, Delhi. I'm going slow so that you can take notes. National Law University, Delhi, NLUD. Go to Project 39A and see their most recent report, which they have just tweeted today. about how several states in the country, including Delhi and Maharashtra, three states, Delhi, Maharashtra, and Madhya Pradesh, the lower courts have gone crazy in the way they have been implementing death penalty, contrary to the Supreme Court directions. Many people have been imposed with death penalty, contrary to the law of this country as established by the Supreme Court. But by going to that website, you will be able to see how a group of academicians and students and researchers are able to contribute to human rights, development of human rights research in this country. It is a unique experiment that the National Law University Delhi has been doing. So please go and visit that website, and from tomorrow, be ready for a lot of activities in the evening. Friends, it is 5:30. By now, you would have also received your connection details for your facilitators meeting. Enjoy the meeting. Akila, thanks once again on all our behalf for what you have been to us, how you have led us. And after you tell me, if you have no problem, I can give them your number. Those of them who want to continuously communicate with you could communicate. But you don't need to answer here. You can answer me privately so that you're not flooded with questions at a time when you are corona stuck and having to be at home. And for those of you who really have questions that must reach Akila, please send them to Matthew. Now, where do you send these questions? These questions have to go to Rajavel, Rajavel, R-A-J-A-V-E-L. R-A-J-A-V-E-L. All the facilitators note, R-A-J-A-V-E-L at pwtn.org. At pwtn.org. It is on your chat. It is on your chat box. Matthew has been kind enough to put it. It is on your chat box, and the death penalty sentencing details are also there. Look at the website. Look at this report. And then perhaps we will decide whether we should have really a panel discussion on death penalty. Then you will know how many people are on the death rows, which legally they should not be according to the law of this country. I leave you here. 1 minute I've crossed. Sorry. Thank you. Thank you, Akila. Thanks. All the best. Closure of day 4.